now I would like to introduce my colleague Christina from IDC. She's also working in the project EU Hubs for Data, and she will be moderating the legal and ethical challenges. So Christina, I guess that you are here in the panel, so the floor is yours.
Thank you very much, Daniel, for introducing me. Just a few more words from my side. I'm a consultant for the IDC for EU European Government Consulting Unit in IDC, which is a global provider of market intelligence and advisory services in the ICT field, and also partner of the EU Hubs for Data Consortium. I'm really pleased to chair this panel session on the legal and ethical challenges. I will be joined in this discussion by two speakers, Mr. Emre Bayamlioglu from the Center of IT and IP Law at KU Leuven, and also the lead of the legal activities within EU Hubs for Data, and Mr. Jyrki Suokas from the Finnish Innovation Fund Sitra, is a fair data evangelist and also the senior lead of the human-driven data economy focus area. So I will now give the floor to Emre, who will explore the legal challenges, and in particular, it will focus on data governance and the Data Act, which was also introduced this morning by Federico Milani from the European Commission. So please, Emre, the floor is yours.
Oh, still good morning, everyone. I guess now everyone can hear me and see my shared screen. So,
yes,
I am Emre Bayamlioglu from Catholic University Leuven, Center for IT and IP Law. We are responsible for work package 3 of EU Hubs for Data, ethical and legal aspects. And we are actually a team of 3 with Peggy Welke as the principal investigator and Julie Valou as my colleague and researcher. So leaving aside the ethical dimension, the legal dimension of EU Hubs for Data, because it consists of 3 tasks divided into four, let's say, documents. One is the internal organization and management that we are going to leave aside today. The second is a state-of-the-art legal analysis to see where we stand. Secondly, we have the application, which we can call the establishing of a data governance mechanism. And thirdly, we could speak about the technical dimension, automated contracts. So based on this conceptualization, actually the concept of data transaction is the kernel of our analysis. At the end of the day, in the legal world, data governance concretize or come into existence through exchanges or acts aiming for the usage of data to empower the recipient for various types of usage of data. So we define the concept of data transaction and we elaborate on that. And accordingly, the legal dimension of data governance, again, this is the conceptualization, structurization we develop throughout the project research. So we can identify 3 pillars of data governance. One is the laws and regulations, but more specifically, substantial rights, major frameworks, which directly affect, facilitate, or sometimes to a certain extent, maybe impede the data transactions. Secondly, data transactions take place in an organizational setting. We can call them data governance mechanisms, where various concepts and tools are, in a way, we could say, elaborated or articulated in various legislative and policy documents of the EU. And thirdly, speaking of data transactions, we can speak about the contractual framework of data transactions or data governance, which decide the use, purpose, and other aspects of data usage, aiming for sharing and reuse of data. So accordingly, the laws and regulation parts, of course, there are various laws and regulations, both horizontal, vertical, sector specific. But among those 4 are most prominent and which are, we could say, of direct relevance to data transactions, any contract or unilateral act aiming for reuse or sharing of data. Of course, we have the renowned General Data Protection Regulation. Here, speaking of in terms of data transaction, an important issue, or we could say the sweet or weak spot of the GDPR in terms of data transactions is the revocability of consent. As you know, in many cases, consent is the basic legal leverage to give effect to any data exchange, data transaction. When it involves personal data, you have some grounds for processing data, and most frequently used referred one is the consent of the data subject, and this consent is revocable. So in this part, we try to figure out how we could limit, shape, and in a way contextualize this revocability of consent so that we could bring some more stability and certainty to data transactions. Coming to intellectual property rights and trade secrets, well, since data has no default legal status, most of the times, one of the most prominent legal framework, legal status could attach to data are the IP rights. So the problem, IP rights are exclusive, and the existing exemptions in the relevant laws are not adequate, so that when they appear as third-party rights, they also stand as a barrier for data transactions. That's an issue that needs clarification. Thirdly, we could speak of competition law. Actually, competition law, like other two frameworks, could both foster or impede data transactions. In terms of abuse of dominant position, maybe speaking of EU hubs for data, the future federation, maybe this is not of great concern, but one thing that we need to be careful, the rules and conditions for the use of data within the federation or offered by the data innovation hubs should not amount to contracts of exclusion or should not limit competition in the secondary or other markets as well. So this is an important issue which should be of consequence, and there are also new developments in the area of competition law. For instance, the new competition tool developed by the Commission, by the European Union. Fourthly, as a kind of emerging framework, we could speak about open data, publicly held data. So far, maybe it had limited scope, but especially as we'll speak soonly with the coming Data Governance Act, this is an expanding sphere. So we could say it is in the becoming of a separate legal regime. So whenever the data transaction involves open or publicly held data, terminology could be questionable, but at the end of the day, when we speak about the data transactions, a huge part of data transactions could involve one way or the other the publicly held data, and then this is something which needs to be taken into account when we are entering into data transactions. So this is a general outlook of the major legal frameworks that give legal effect or regulate also, we could say, data transactions. In addition to this, there is this emerging body of legislation, which is declared in the European Strategy for Data in February 2020. So especially under this legislative agenda, we already have the proposal for Data Governance Act. It touches upon many different aspects of, let's say, data governance. And more importantly, and expected or that we are awaiting the Data Act in the third quarter of 2021. This directly cuts across our analysis, especially the part that we are going to have on the contractual framework and also on governance, because it is expected to provide some framework for business-to-business data sharing This also means that there will be a certain, I would say, a calibration of IP rights so that they will not stand as a barrier for data transactions. So on the organizational part, data governance mechanisms, as we said, several concepts and a wide range of terminology have been explored and identified. But if you want to look at in general, we could identify three main functions with data governance. First, the bringing together data holders and data users, or data providers and data users. Actually, they somehow realize, bring into effect the actual transfer, actual use of data, and they also involve a technical infrastructure, a certain capacity or affordance of programmability for the use of data. So automating data transactions and data use. So the most important legal instrument in the EU legislative agenda is the Data Governance Act. It has a bearing on our legal analysis and the future of the federation as a one-stop shop, as an overarching umbrella organization. Of course, Data Governance Act is of great relevance for the project and also for the future federation that will be created by the end of the project. So Data Governance Act, okay, it kind of further expands publicly held data. So that's why we think that the open data, publicly held data is in the becoming of a separate regime. More importantly for data federation, or generally for data governance mechanism, is the new rules and the new definition of data sharing services. This is for utmost significance for us for the time being. We have a novel concept, a novel introduction, data altruism organization, which again appears as a special type of organization with certain conditions and requirements. And whenever the federation will deal with data altruism organizations, or maybe receive as a member a data altruism organization, this will also bring its a specific regulations. And fourthly, we could speak about the board for coordination and interoperability. So looking a little bit more into focusing more on data intermediaries, or we could call under the data sharing services. So this is a kind of regulating data governance organizations under the heading of data intermediaries. And in addition, we have another concept, data cooperatives. The point is that the definition of data sharing service is vague. However, the consequences are strict. So far, this is our most significant concern with regard to the Data Governance Act, because when we look at the provisions, it could cover a vast range of organizations. It could definitely cover federation. It could definitely cover digital innovation hubs, and it could also cover any kind of infrastructure providers. So we could say this current unclarity appears as a difficulty for us in terms of clarifying the legal dimension of data governance. We also have a new introduction, data cooperatives. Actually, that's again a novel introduction. The point is that it is not very clear whether this new organization connects with the official form of cooperatives, European Cooperative Society, regulated under EU law. So there is a kind of maybe a missing connection, or maybe this will clarify when the initiative unfolds. But basically, our main concern is that who is a data sharing service? Because once you fit into this description, it comes with serious restrictions and notification duties. We should also mention that maybe such strict notification duties or conditions could also be, to some extent, maybe a disincentive in that sense. So coming into contractual framework, okay, one of the main problems about contracting over data is that data has no official legal status. So there is no defined ownership on data when it is protected by IP rights. Okay, this to some extent creates some exclusivity, but apart from that, two or more parties entering into a data transaction, they do not have a total rights or legal status or an ownership like connection with the data so that they can contract over. So in that sense, the much awaited Data Act in the third quarter of 2021, as mentioned in the morning, will bring a certain clarity on this aspect. At least it's going to bring some regulation in terms of co-administration of the data, industrial data, sensor data, or Internet of Things data. So it is expected that they will define some co-administration regime. We don't want to call it really rights or ownership, because this does not fit into what is expected here. But basically, this defined regime could define some maybe proportionate and equal standing. Well, that's our kind of articulation or elaboration of the concept. So co-administration regime could have a proportionate part of rights, or let's say empowerments, which are based on the role or contribution to the creation of data. And secondly, maybe we can have equal standing rights, which could relate to permit the use of data for public good, correction, aggregation, or deciding about further commercialization of data. More or less, similarly, we need a regime kind of guiding us on those principles. We still don't know what is going to come with the Data Act, but we are preparing and we are going to shape our analysis once we have the proposal in the third quarter. As I said, this directly cuts across our governance part of our analysis. So coming to contractual terms, well, this is a more familiar topic. Also, we see a similar attempts or development of modalities also in the, for example, IDSA architecture framework. So we need a contractual scheme which will decide which data or data source, and it will decide the degree of control. As you see, we find it of significance or two major distinctions in terms of control of data, whether you are allowed to have a permanent copy or you're going to only have access, search, or other analysis functionalities on a platform or through cloud. So you will not have full control of data. This distinction, I guess, also responds to the concern mentioned. Once you give away the data, you will never know whether the limitations defined in the contract will be adhered to. So we find this as a cutting point in terms of control. Of course, we could elaborate and multiply this, but then we are running into conflicts and overlaps. So part of our work under EU Hubs for Data is also lexicon building, terminology building. We are trying to bring consistency to the concepts like data usage, data transaction, control, and so on. So we are trying to bring some, well, to some extent, order, at least to the best of our understanding, so that it will be more amenable to legal analysis. The contractual part also could decide about the modification, adaptation, whether these will be allowed, whether you can aggregate this data with other data, the duration, whether you are allowed to share it with third parties, or what to do with results. And well, least but not the least important is how to allocate the proceeds, how to share the money, funds coming through. So this is in a nutshell, in a very briefly, the legal challenges throughout the structure of legal dimension of data governance and data transactions. Thank you for your patience, and question and answers are most welcome. And I guess I quite a bit adhere to time limitations, I guess. Thank you.
Thank you. Thank you very much, Emre, for this overview of the legal aspects of data governance and the Data Governance Act. So now I would like to give the floor to Jyrki for addressing the ethical concerns. Please, Jyrki, the floor is yours.
Excellent. Thank you very much. And can you hear me, Christina?
Yes, thank you.
Very good. So I'll start sharing my screen. Just a moment. And there we go. Good. So my name is Jyrki Suokas from the Finnish Innovation Fund Sitra. And my day job is working on the business models of fair data economy, but here addressing the ethics side of doing things the right way, doing things the right way. So talking about Sitra first, Sitra, the Finnish Innovation Fund, we are a think, do, and connect tank, a future house trying to build a better future for all of us. And the project we have been running now for the past 3 years, the Fair Data Economy Project, we've been building the foundations for the technical, for the legal, but also for the business side, containing a sort of overarching theme of ethical way of working in all of the things we do. So in this presentation, we're going to concentrate on data ethics. So how data is being used, how data is being collected, how it's managed, how it's utilized and shared. So we're not going to touch the wider ethics or digital ethics. Data ethics is the focus of this. And in this complex world of ours, it's no longer sufficient to look at from one single organization's point of view, looking at data, because of the very, very complex world of ecosystems, data sharing ecosystems. And here's a very simple example from our digital project, where we looked at the ways the ad tech world shares our data. We had 6 subjects using their phones in everyday interactions with different services. And we had one could say a spy program looking at where the actual data of the usage and who actually gets the access of our data when it's being processed and progressed through the complex networks. So the problem, sort of the way we see this, is that there is a term what we have been using, data colonialism, meaning that us individuals, especially, we are in a not so nice situation when it comes to the large giants, the big data corps, mostly US and mostly China-located big data corps, the asymmetrical nature of these relationships, where us individuals, we are very, very small compared to the large corporations. And when looking at ethics, a model where we have the way of addressing the ethical dilemmas could be seen as a triangle, where us stakeholders, individuals, but also companies, owning data or having data about them accessed and being utilized by businesses, the blue ones on the bottom left, to create some sort of value through services. We can see that the ethical dilemmas, we can focus on all of the different sides of the triangle to see how the problem, the issue, the challenge, the dilemma could be solved. And there's a model here adopted from research done by Gartner, the IT analyst company, that there are 3 ways to solve or deal with a dilemma. One is the trade-off, your way or highway, or actually my way or the highway, which is the trade-off. And it can be 100%, 0% way of having a balance or compromise. It can be the resolving. How can we actually find a mutually acceptable way of accepting the result on both sides, or even improving? How can we improve the situation on both of these sides? And in a couple of slides, I'll show an example of how the 3 different ways to deal with dilemmas can be utilized to solve a challenge. And then addressing the dilemmas, looking at the dilemmas, looking through these four lenses, answering the questions about compliance, about risk, about differentiation and values. So you can see that this goes further and further and deeper into actually the areas of values. How do you make decisions matching your personal values and the values of the company from the pure starting point of, am I following the law? So here's an example, again, adopted from Gartner. So privacy and safety, dilemma, ethical dilemma, collecting employee medical data regarding COVID-19. Very, very sort of important and very, very factual event or dilemma that we are almost all of us addressing almost every day. So looking at the four different lenses, there is an answer yes or no, and then there is a different ways to address this. The trade-off, okay, we collect the least amount of data, but do we get the benefit of this? Then we can resolve this, okay, let's not store the data by ourselves, but utilize one of these data intermediaries we have been addressing in the previous presentations today, or even having the improvement going above and beyond the system and creating something that actually then is much, much better for both sides in the dialogue. And commitment that we actually need to do, and especially when it comes to individuals, that the ethical practice should be a common call for all parties. And we are very much working along this development to make sure that everybody understands. It is the larger companies, it is us individuals, it is the government, the regulations to regulate these. Everybody needs to understand that ethics is the sort of the foundation, the deepest foundation for all of the work that we should be doing when it comes to data. And the participation, of course, is a challenge, and especially the challenge is the participation of the individuals, the small, tiny people represented in this world by who? So that is the real question, that how do we find a way to get the participation of the individuals in this very, very important matter? In the work that we have conducted, one of the tools, frameworks that we have created in our project, the Fair Data Economy Rulebook, a way to manage the many-to-many relationships, many-to-many legal contracts within a data sharing ecosystem. We've created a ethical foundation, ethical basis by creating a set of common values in our code of conduct, well ingrained and well within the boundaries of the rulebook, not just addressing the legal, not just addressing the business side or the technical side, but very much focusing also on the ethical side of approaching and doing, as it says in the cup, what good shall I do this day? And we have created an initial maturity model where the level 0 is, okay, many of us can see that the level 0 is actually in many places the current situation, that there is now no trust, there is no privacy, and the fair network. All of this is something that we have seen, that creating a model, a maturity model that actually helps organizations to understand the current state, the target state, and actually what needs to be done to move from the current state to target state is really, really important to nudge organizations, to nudge regulation towards a more ethical, more fair way of working. And this is the core and the essence of fair data economy. So it is a way to create value out of data in a way that benefits all of the different parties, all of the different stakeholders in a fair way. It is the vision of our vision that there will be, not there should be, but there will be a well-functioning data market where data can be accessed by even smaller companies, can be accessed by the larger companies in a way that is done in a responsible and an ethical manner. If we look at the way, again, from the individual's point of view, GDPR was an excellent start coming into force almost 3 years ago, but it's providing a obscura, a very, very small hole looking at the black box of data. But we do see that we need to go way beyond this. We need to be able to have full transparency on how our data is being utilized, how our data is being used, and how can we as individuals benefit from our data being used for good. And at the core is fair data principles. The principles, the listed ways of working for organizations and companies that really build trust, create the trust, create the transparency, and eliminate the friction of participating in data economy. Make it easier for the companies to do things the right way. And we have a concept called ASET, the fair data economy. And the fair data economy is something that doesn't exist yet. So in that sense, where we are more or less today is here on the left. Some individual organizations starting to follow the fair data economy principles, creating ways for their customers, for their partners to benefit from the value creation in a fair way. But the next step involves data sharing. And this is this sort of in the middle, these circles where organizations adhering to fair data principles are working together, adhering to the same rules, utilizing the rulebook approach, creating these small data sharing ecosystems where data is being shared and value is being created. But then evolving to the right, where a multitude of these companies or the majority of these companies working in a fair way actually then creates the fair data economy. And of course, we do need technological components to make things work. We do need regulatory components, and all of the regulation published last year and this year is an excellent step towards a much better and fairer world. We've created a tool called Fair Data Economy Score. That is a self-assessment tool for larger organizations to understand their current standing in fair data economy. It looks at 5+1, and that +1 is the data sharing and ecosystem participation here on the left. Dimensions, roughly 50-60 questions, where we also give recommendations for moving from the target to the target state from the current state. And the actionable analysis, the report that is being created for each and every individual organization performing the assessment then gives ingredients for development roadmap initiatives, moving the companies towards a fairer data economy, being a fairer data economy player. Another example, the largest bank here in Finland, OP Group, they are already now for the third year have published their data balance sheet, how their data strategy is being utilized, how they collect data, how they utilize data in a very transparent way, exactly like the companies are publishing their standard financial balance sheets and financial statements. This is about how to make it transparent, open to the public, how they use the data of their customers, how they use the data of their partners. And we're not here alone, of course. There's plenty of work being done to move the world towards a fairer data economy, fairer world. And just to mention some of the tools that have been utilized and have been created, and they are free for all to be used, because that's the way we here in Sitra operate. Okay, that was faster than 15 minutes because I thought that we actually do need a bit more time for the final panel discussion.
Thank you very much, Jyrki. It has been really interesting to understand more about Sitra's work towards this fair data economy and the fair data economy principles that you are spreading out. So thank you, Emre, also for joining this panel discussion. Since we are a bit behind schedule, I would like both of you to address the same question from the different perspectives, so from the legal and ethical one. So can you please, among the different challenges that you presented, can you please point out one that you think could have the biggest impact also in the next years, and also highlight a potential solution. So maybe Emre, can you please start highlighting a solution in the legal and IP field?
Sure. Well, as you said, maybe the biggest challenge it will be in the IP area, because it is a well-established, rigid regime, and the current exemptions are very limited, inadequate. So we are expecting some calibration in Data Act, but it seems there is still a huge gap between articulating or formulating some solution and putting it into practice. So this is, and maybe one other difficulty, the current legislative agenda is a bit pulling too many strings all at the same time with too many moving parts. There is a certain regulatory complexity that many interconnected instruments have to be finalized within a year or 18 months. This is a real challenge. And sometimes the current legislative agenda needs to contemplate a lot, because the markets are not saturated or mature enough. So they somehow, in a way, fictionalize certain market conditions and in a way generalize, or sometimes maybe overgeneralize some specific problems, I would say.
Thank you, Emre. So Jyrki, what is your view from the ethical side?
Well, the biggest thing about ethics is it's the hard, soft stuff, so to say, that it is conducting things the right or the wrong way. And again, it is black and white, or is it somewhere in between, being some shade of gray? So in that sense, from our working point of view, the sort of quantifying from the financial point of view, the value of doing things the right way, the ethical way. That is extremely important, that we can show, and there is a massive amount of evidence showing positive correlation of doing things the ethical way versus, let's take, for example, Enron from 20 years ago, or Bernie Madoff, the financial impacts of doing things non-ethically. So there is a clear correlation between being non-ethical and then losing your customers, losing your partners, losing the business. But finding a magic formula, somehow a magic formula, sort of showing that doing things the right way, conducting things the ethical way, having then seen the financial results. That is actually then the final convincer, so to say, for the business people, the deciders, the C-level people, to really that we actually need to take this more seriously.
Thank you, Jyrki, and thank you both for this interesting discussion. I think we can now give the floor to Daniel, since we will have a final roundtable with all the speakers involved. It would be interesting to have you all together discussing